as professionals, let's assume that you're an architect and you're engaged as a designer or as an assigned certifier. Your main contract will be with the employer or building owner. But you have potential liability to many third parties outside that relationship, and there are actions of third parties outside your contractual relationship which you can't control. And that's been a theme that has come through in the presentations from Deirdre and from Owen. The ancillary certifiers, the contractor. Barrett talked about including an express obligation on the contractor to cooperate with the assigned certifier. When I first looked at these regulations nearly 2 years ago, I gave a seminar, I gave a short talk about them in Engineers Ireland, and I said, I'm a practicing solicitor and I can tell you, rounding up collateral warranties, even on a small project where there might only be 6 sets of collateral warranties, is an absolute nightmare. It's a whole project in itself trying to secure those. How on earth is the assigned certifier going to round up all of those ancillary certificates in an acceptable format such that they can comfortably sign the completion certificate? And won't employers have to take on that project management role themselves? And that's essentially what Barrett was saying as well. It's very important that employers understand that aspect of your work and that you are not left at the 11th hour when you are the person preventing the building from being opened saying, but I can't sign that completion certificate, and here are the reasons I can't sign it. It's very, very difficult perhaps to anticipate the reasons you won't be able to sign it at the beginning of the project, but there's a certain amount that you can do to try and forestall those types of issues. So the purpose of this really just is to set the scene for the idea of third-party liability, which is what we'll be talking about. So the tort of negligence, I give you Lord Atkin. Lord Atkin famously delivered a judgment in the case of Donoghue and Stevenson in 1932, which exploded the tort of negligence. Up until then, the tort of negligence had really existed in quite confined categories. Every law student is aware of Donoghue and Stevenson. It introduced a neighbour principle where essentially, from that point on, the law would impose a liability between you and third parties if you damaged their property or if you caused them physical injury. And that is the essence of the tort of negligence. And one of the most famous concepts that arose from the case was the duty of care. And the court said, and it was a House of Lords decision, that a duty of care can be owed to third parties in respect of physical injury or in respect of damage to their property. So that is what you were seeing. When somebody crashes into your car, you have no contractual relationship with them. You have no way of allocating that risk before it happens, because you don't know if it's going to happen. It's an accident. It's damage to your property. It's covered by the tort of negligence. It's now covered by insurance, and that is how that works. So generally, what I want you to remember about the tort of negligence is that it responds to, or it applies to, physical injury, damage to property. Oops, sorry, I don't know why I have 2 blank slides there. Barrett mentioned economic loss. If somebody crashes into my car and I have a very important set of tender documents for a contract that I want to win on the passenger seat, and I have a deadline of 12 o'clock, somebody crashes into my car at 11 o'clock, I miss the deadline, I'm out of the competition. I can claim for the damage to my car. I can't claim against the person who crashed into me for the lost contract. So the tort of negligence has not gone that far. It doesn't require us to protect one another against the cost of our actions beyond damage to property and physical injury. This has been established in a number of cases. Candler v. Crane Christensen Company was a 1951 decision in which this principle was reaffirmed, and the court said, Donoghue and Stevenson is now 20 years old. It was always intended to apply to physical injury, damage to property. It doesn't cover economic interests. That case covered negligent auditing of a set of accounts, and it was an English court. They wouldn't allow recovery in tort. There was a dissenting judgment in that case from Lord Denning, who said, well, I don't see why economic loss shouldn't be recoverable if there is a reliance and an assumption of responsibility for advice. Why should we not require professional people to take care when they are giving advice? 12 years later, we had Headley-Byrne versus Heller and Partners. That case is the foundation stone of professional negligence claims against me and against everybody in this room. And the irony of it is that the defendants in that case, it concerned a credit reference given by a bank. One of the bank's customers was entering into a big contract, and that person's customer rang the bank and said, are they in good standing? Because before we accept this order, we want to make sure that there's enough money in the bank. And the bank said, yes, their accounts are in very good order, but we're not responsible for this statement. We're not taking any legal liability. And then a request was made again, and the bank came back in writing this time, and they said, the accounts are in good order, but we take no responsibility for this. The House of Lords said that where a person possessed of a special skill applies that skill for someone else and makes a statement and gives advice, this gives rise to a duty of care to protect the other person from economic loss, because what was lost when the customer became insolvent was the cost of those orders. It was quite a substantial cost. The defendant in Heller and Partners was found not liable because they had used a disclaimer in their oral advice and in their written advice. And this is a very, very important point, which we're going to come back to when we look at the design certificates. I refer there to the cases of Murphy and Brentwood and Robinson versus Jones in the Court of Appeal in 2011. The combined effect of these two cases, to put it simply, is that economic loss is recoverable for negligent misstatement. Design is regarded as a misstatement, but the work of a builder is not regarded as a statement. So in Murphy and Brentwood, the House of Lords said, if a building is defective and is dangerous, then that could cause injury, and that gives rise to liability under the tort of negligence. If a building is defective and it hasn't harmed anybody and it hasn't damaged any other property, that is a defect of quality. The building is worth less than you thought it was worth. It's economic loss. It's not recoverable under the law of tort without this special relationship of reliance, which was established in Hedleyburn and Heller. So Murphy and Brentwood essentially said, we will leave this type of economic loss as being available against professionals. It is not available against builders. Robinson versus Jones in the Court of Appeal said exactly the same thing in 2011, but went a little bit further and said, concurrent liability, where you can be liable both under the law of tort and under the law of contract, exists for professionals in the Hedleyburn category, and it doesn't exist for building contractors. So just try and hold that thought while I bring you through to the design certificate. Under Irish law, the position is less clear, which presents a certain risk to you in terms of managing this liability. There is a case from 1985 which went to the Supreme Court in 1988, Ward versus McMaster. The vendor of a house had made a really shocking job of building the house. The family that bought it sued. They recovered against the local authority, and they recovered against the builder, even though it was a defect and even though it was economic loss. In doing so, the Irish courts approved a line of jurisprudence from England, which has since been thoroughly discredited by the English courts. And the experts believe that economic loss under Irish law, probably if it came before the courts now, would be treated in the same way as the English law. The Irish courts have had to look at this a few times in the last 20 years, and they tend to say, we're going to leave that question for another day. One of the leading cases was Glencar Explorations. The Chief Justice in 2002 said, economic loss is recoverable in actions for negligent misstatement. I'm going to reserve for another day the question of whether it's recoverable generally under the law of negligence, whether it's recoverable outside of categories such as Ward and McMaster. So it suggests that it is recoverable against a builder, but it's definitely not clear, and I wouldn't be at all confident about that. I suspect, having spoken to one of the experts on it, that one of the people who wrote the leading textbook on the law of tort, that now under Irish law, economic loss would be regarded as recoverable against professionals, like you, for example, for defective design, not recoverable against builders. So, turning then to the question of liability. Liability under contract and tort arises very, very differently. So liability, and let's just be clear, liability is a legal obligation to account for something that you have done. Responsibility is a different thing. So responsibility I would characterise as a question of fact. Liability is a question of law, which is why you can end up paying the cost for somebody else's default for reasons that I will come on to. Liability under the law of tort is non-compliance with the contract. For example, your professional appointment or the building contract. It is why it is so important to have written terms of engagement that specify what you are being engaged to do. Particularly important for you practicing in this uncertain environment and with these very, very high potential risks to third parties. Particularly important for you because you are subject to a different standard of care, a different legal duty than the builder that you're working with.